I am Michael Marnick, the Chair of the Zoning Board of Appeals of the Town of Orleans. And this is a special meeting duly noticed of the Zoning Board. Present, besides myself, the Chair, our Vice Chair Matthew Cole, and regular members William McCarthy, Rolf Soderstrom, and Beth McCartney. Also present are the Board Secretary Sandy Stewart and the Building Commissioner of the Town of Orleans, Tom Evers. In attendance and who will address the board is Michael Ford, the Town Council of the Town of Orleans. Present by telephone are associate members Gerald Mulligan and Peter Jablin. Members of the board, the purpose of this meeting, as the notice indicates, is to consider and discuss what action, if any, should be taken in connection with a document entitled Petitioner's Notice of Constructive Grant of Variance and Objection Deadline. This was filed with the town clerk on December 17th, 2015. It is a two-page document with an attachment with a list of names, purportedly additional people who to whom notice was given of the document. The document has been submitted to all members, and the question is what the zoning board should be doing with this. To refresh the memory of the board, on December 2, 2015, by a vote of 3-2, the zoning board voted to deny petitioner's application for a zoning variance. At that time, by unanimous vote, the zoning board decided to defer or to allow until January 6, 2016 to file the decision of the board, which would be announced at the next regular meeting of the zoning board on January 6, 2015. Petitioner, in summary, claims that since the application for a variance was filed on July 10th, 2015, that the zoning board failed to act on the application within 100 days of the filing of the application, and also the board failed to file its decision with the town clerk within 14 days at the end of the 100-day period, or within 14 days of the final hearing, whichever happened first. The question is, what should the zoning board be doing next? The town council is present to address the choices, and I'm going to call upon Mr. Ford, please, to explain what action we could possibly take, or inaction for that matter.
Sure. Thank you, Mr. Chairman, members of the Board of Appeals, and those on the telephone, Sandy and the Building Commissioner. This matter was brought to my attention as Town Council last Tuesday when I was at the Town Hall on various matters, and a copy of what the Chairman has referred to as the Petitioner's Notice of Constructive Grant of Variance and Objection Deadline was provided to me. In attendance were the Building Commissioner, Sandy was in attendance, George Meservey, the Town Planner, joined us, and I reviewed with Mr. Kelly what the options were as a result of the filing of this petition. And one of those options was to take an appeal from the allegation in the petition that a constructive grant has occurred. And I advised him that that appeal could be taken by the Board of Appeals. It was their discretion, their call as to whether they felt such an appeal should proceed, but that there was a narrow time frame in which to take that appeal. It's the same time frame that one would need to take from any one of your decisions, which is 20 calendar days from the time there's a filing with the town clerk's office. And this claim of constructive grant is treated the same way, both by statute and by the courts. So the appeal from this to challenge either the allegation there's been a constructive grant and or, if there has been a constructive grant, to challenge the merits of the variance, both of those need to be raised within that 20-day period. Parties in interest who were also given notice, or as the chairman said, were purported to be given notice by the filing with the town clerk, also have the same rights of appeal, just the same as the board would. So this is treated almost as if it was a decision of the board. The difference, of course, is that here the vote was 3 to deny and 2 to grant the variance, or opposed to the denial, let's say. I guess there was never an affirmative motion on the floor, as near as I can tell in examining your minutes. So I think it's probably constructive in the first instance to review the time frame in which this notice of constructive grant comes forward, so you can kind of put it in perspective. The facts as they've been given to me, and many of which have been independently verified by me over the last couple of days, because Mr. Kelly had asked me to look into it, are as follows. An application for a variance was duly filed with the town clerk and this board on July 10th, 2015. By statute, the board has 100 days, start to finish, to decide a variance petition. This is different than a special permit. Special permit, you have to hold a hearing within 65 days, and then you have 90 days from actually the close of the hearing. Most courts say, hey, it ought to be 90 days from the start of the hearing, but it's a little unclear. But you have more time with a special permit. There's no question about it. But this was a variance, so this was governed by the 100-day rule. So if we were to take July 10th as the date, 100 days, under my math, would have expired October 18th. So let's look and see what happened during that first 100-day period. The matter was duly advertised for a hearing, and indeed a hearing was opened up on September 2nd within the 100 days. And at that hearing, at least the minutes that I have reviewed, simply say the applicant was represented by counsel, Dick Lariah, and Tim Brady, surveyor. The members were designated by the chair as to who would sit. And then the minutes provide that at the applicant's request, applicant's agent's request, so I assume either Mr. Lariah or Mr. Brady, a motion was made by a board member, seconded, and it passed unanimously, to continue the hearing to November 4th. And as near as I can tell, although it's not set forth in these minutes, the reason for the continuation was that the board requested a more detailed plan, an actual surveyed plan of what the lots would be, one which I guess at the end of the day could also be submitted as a plan, an A&R plan, to the planning board in the event that this board granted relief from the the zoning requirements for which the variance was sought. So, the facts we then have as of September 2nd are, applicant makes a request for a continuance to November 4th beyond the 100 days, 100 days being October 18th. There's nothing on the face of the minutes that either the applicant or the board referred to the 100-day time limitation, so I'm not sure it was on anybody's mind at that point, one way or the other. The matter was continued to November 4th. The minutes of the September 2nd meeting, which may have some significance, were filed with the town clerk. Why is that perhaps significant? The 100-day time limit under Chapter 48, Section 15 can be extended by agreement between the applicant and the board, provided it's a written agreement, one, and two, the written agreement is filed with the town clerk. So I suppose one could argue, while this may not have all the formalities of, quote, an agreement, one might be able to take the position that the fact that a motion was made on the request of the applicant to extend to a time period beyond the 100 days, and a copy of that motion was filed with the town clerk, perhaps. I haven't found a case that I can tell you that says that that could happen. So we might be in new ground here, all right, as to whether or not that satisfies the statute. So then what happens? Prior to November 4th of 2015, an email is received by the town, and I guess by you as clerk, from counsel for the petitioner, Mr. Lariah, seeking a further extension. That came in sometime around, I think, October 31st. And so the board, at its meeting on November 4th, considered the request for further extension. And again, the reason given by the applicant's agent, Mr. Lariah, at that point was the plan was still in a working mode and wasn't yet prepared. So the board on November 4th votes a further extension at the applicant's request to December 2nd, 2015. We're well beyond the 100 days now. Again, I can't find anything either in the applicant's request or in the board's grant of the continuance on November 4th, and I haven't seen the November 4th minutes, which would suggest that either party was focusing on an extension of the 100 days. If any of you were there at the November 4th meeting and recall there was some discussion about that, please tell me, because that could be material. But the fact that at least there's nothing on the face of anything that I've been shown that either party mentioned it. So we have, and I don't know whether the November 4th meeting minutes have ever been filed with the town clerk. When I looked online, it said the minutes were pending. The November 4th are filed with the town clerk. Okay. All right. So Sandy tells us they are. So again, we have a situation where you got a request from the applicant to extend or to continue, doesn't use the word extension, continue the hearing. Board grants, neither party is focused on the 100 days, but Sandy tells me those were also filed with the town clerk. So do we have the makings of an agreement? Perhaps. Again, it's very similar, I guess, to September 2nd. So then on December 2nd, the plan is in. I understand it came in just before the hearing. And after deliberation and whatever other testimony was taken and an examination of the plan, a motion was finally made to deny the variance. 3 voted in favor of the denial, 2 in opposition. So the board acted on the application. There was a vote. There was action by the board. We're well beyond the 100 days. but arguably were within a window in which the applicant had requested continuances which might be able to be characterized as extensions. So it seems to me it will be constructive for you, before you decide what you want to do, to kind of look at a couple of ways that you can view what happened. First, you could view it as, okay, the 100 days was extended because the applicant asked for it, and the board granted it, and the minutes were filed with the town clerk. And then the board voted on December 2nd. The statute further says that the board has to file its decision within 14 days of the time that you take action. Question is that mandatory or is that directory? The cases say that if the 14-day period will take you beyond the 100 days, it's mandatory. If the 14-day period doesn't even get you to the 100 days, you got more leeway. You just have to do something the 100th day. So, how does that fit here? If there was an extension to December 2nd, then the 14 days would have expired at the close of business on December 16th. That apparently is how the applicant is construing it, because on December 17th, they requested this finding of a constructive grant. There is a question, however, in my mind as counsel, as to whether the constructive grant request is timely from two perspectives. First, Chapter 48, Section 15 says if an applicant wants to request a constructive grant, they have to do so within 14 days of the 100 days. Well, first of all, 14 days of the 100 days, if there were no extensions, and there's certainly no written agreement signed and filed with the town clerk, is 14 days after October 18th. So the time in which they could have requested a constructive grant without a court finding that what happened here was really extensions is long since gone. All right, that's one view of it. Second view of it is, let's assume that these were extensions within the meaning of Section 15, and it was extended to December 2nd. Well, they needed to request a constructive grant within 14 days. That would have been the close of business on the 16th as well. They filed on the 17th. So under that theory, they may be too late as well. Or there's a third way to look at it, I guess, although I don't put too much stock in this one, that when the applicant asked back on the September 2nd meeting for an extension, it told the 100 days. In other words, 54 days had gone by, and they just stopped running. And they stopped running through the applicant's extension request all the way to December 2nd, and then the remaining 46 days have just started to run since December 2nd, and you've got till the middle of January to file your decision. However, the statute doesn't use the word tolling. A lot of statutes do. I checked the case law. I haven't found any cases that support tolling. The statute speaks in terms of extensions of the time period, not tolling of the time period. So there are some practitioners that feel, well, maybe there was a tolling. There was no discussion, obviously, by board members or the applicant about that. To me, I think that's not one that I think a court would ultimately find actually occurred here. So what are your options? Your options are, one, do nothing. Simply let the town clerk react to the constructive grant request as she sees fit with a reading of the statute. Frankly, if asked as counsel, I would tell the clerk that I think the request is too late. and I would advise the clerk not to issue a notice of constructive grant. That would probably precipitate an appeal by the applicant. I don't know. If it turned out that the applicant's request was found to be timely and the applicant had taken an appeal, well then the board, having not taken an appeal, would be out of the picture. It would simply be a case between the applicant and the town clerk. In order for you to be involved in the matter as a board, you have to file an appeal before January 6th. Where's the January 6th date come from? It's 20 days from the time they filed this with the town clerk. Remember I said this is treated like a decision? If you're going to appeal this, if you're going to object to it, and the allegations contained therein, you've got to file an appeal by January 6th. What would that appeal say? It would, I assume, if you decide to vote to take such an appeal, it would disagree that there was a constructive grant. And there are a number of theories that could be brought forward, one of which is this is simply untimely. They didn't ask for extensions. We didn't grant extensions. We granted continuances. The 100 days came and went. Nobody focused on it. So they're too late now coming up and waving a piece of paper saying, hey, we know you voted 3-2 to deny, but you didn't follow the statute. The other issue that could be brought up in an appeal, if it's timely taken, is to challenge the merits of the variance. And what do I mean by that? Let's assume any such appeal took 2 counts. First count would be that the board takes the position there was no constructive grant and would ask the court to so find. The second count would be that, assuming, arguendo, that the court found that there was a constructive grant, then the board challenges the variance on the merits. And the statute gives certain parties the right to do that. Now, I say certain. What do I mean by that? Certainly any parties in interest who got notice would have a right if they could otherwise show standing. The planning board could have been a municipal board to take such an appeal. I met with the planning board this afternoon. They decided not to vote to take an appeal. They thought it was a Board of Appeals matter, and whether they acted timely, and you folks should make that decision yourselves. They shouldn't be jumping into that. That was the thrust of it. So they did not authorize any appeal from the planning board. But count 2 gives you a right, if for some reason the court found that they did everything right and this was a constructive grant, to challenge it on the merits, which would mean that there'd be a de novo hearing, and the applicant would have to show that there was evidence that there was unique conditions relating to soil, topography, or shape of the land or the structures located on this lot that are unique to this lot, not generally the zoning district, such if you apply the bylaw literally, it creates a hardship, and that the granting of the variance wouldn't be against the spirit and intent of the bylaw or detrimental to the public good. All 3 prongs they'd have to find. And if a court could find that from that evidence, that's a very high bar, we all know, to prove variance conditions, well, then a court could uphold it. So that's the reason to bring count 2. Now, is there any precedent for a Board of Appeals bringing in count 2? I found a case, the Hadley case, where the board appealed a grant of a constructive variance. The court found there was a constructive grant. The board hadn't acted timely. The board never challenged the second part of the case on the merits, and therefore the holding in that decision leaves open the question of whether a Board of Appeals, whose inaction may have resulted in a constructive grant, does have standing to challenge the decision then on the merits. So that question really hasn't been answered. Certainly if you decide to appeal, my advice would be to bring that second count as a belt and suspenders, if that's what you decide to do. So, you can do nothing. You can vote to take an appeal That appeal would have to be filed by January 6th, and that would be a challenge to this set of allegations that you failed to act timely. In either event, whichever you decide, I think you should go forward on January 6th and make your findings of fact, and then file subsequently your decision with the town clerk. And you may say, why? Isn't it all moot at that point? No, it's not. And the reason I would suggest that it's not is that if it's found that their request for a constructive grant is untimely, then it's important that you follow through and file your decision, because then it's all very much in play. And you should file it with the town clerk, and they would have appellate rights from that decision as they deem fit. So that's kind of an overview. There's a lot there, I know.
And now, Mr. Ford, where is the appeal filed?
The appeal is filed in, obviously, a court of competent jurisdiction, and there are several courts that are of competent jurisdiction. The Superior Court here in Barnstable County. You can actually file in the district court, although it's very rare that a zoning appeal is filed in a district court, or in the court of preference for most zoning lawyers, the land court. If such an appeal is authorized, I would file in the land court. I just feel the land court judges have the most experience with zoning appeals.
And who represents the position of the zoning board of appeals? Town council?
The town administrator has directed me, since you've got such a short window here, that if you decide to appeal, I would file the appeal on behalf of the board. And then the matter would be brought before the Board of Selectmen, since they must approve all lawsuits because money gets expended. And the selectmen, it would need the selectmen's acknowledgement and consent to continue on with the case.
When is the next regular meeting of the board?
Next week. I'm before the board on a number of matters, and this would be added if you decide to appeal.
Would that be before January 6th?
No. It's the evening of the 6th, so the appeal would be filed before the meeting.
May I ask a question?
You certainly may.
This is Peter Johnson.
Hi, Peter.
I apologize for the noise before that. I wasn't aware of it. And in any case, that I'm kind of piggybacking on a question just asked, if I heard it correctly. Could the selectmen review slow down on filing the appeal and cause us to miss that date of January 6th?
No, the town administrator has instructed me as town council and to proceed with both this meeting with the planning board and the Board of Appeals tonight, and if the board votes to file an appeal, to get the appeal filed timely, and then to bring that to the attention of the selectmen to see what they want to do in terms of. No, he does not want you to miss that window.
Thank you very much. You did a really great job. At the same time, I'm just going to tell you right now that if I have a vote, I hope to file this and bring up those subjects that you mentioned.
Thank you, Mr. Jablin. And Mr. Mulligan is also with us. Let the record reflect that Mr. Jablin and Mr. Mulligan are associate members of the zoning board, both of whom were in attendance at all of the hearings regarding this application. However, for the purposes of any decision this evening, I am ruling that the regular members in attendance, all 5, will be voting to determine what action will be taken, if any, on behalf of the zoning board. That's on advice of town council. Let the record also reflect that there have been no communications known by the chair amongst the members of the zoning board regarding the issues being discussed at this meeting, except for series of emails which have been distributed amongst the members. Most of the emails have been initiated by Associate Member Bruce Taub, who was in attendance at all the hearings regarding the application of Mr. Arabian, and who is out of the country presently. But those emails will be made part of the file. Otherwise, if any member is aware of any ex parte communications other than Mr. Taub's emails or emails which all members have received, please make that statement now. Let the record reflect that there's no positive response. Excuse me.
Mr. Chairman, I would just, for your consideration, the one email that I sent marked for procedural purposes only and not intended to be a substantive discussion of the merits related to, I think, whether one had to view prior proceedings of the actual case. So that is.
We've made that ruling now.
So yeah,
But that communication we made part of the record too.
okay. That in the interest of
In the
inclusion.
file,
Yeah.
for completeness.
Okay. Thank you.
Mr. Mulligan, do you want to have any questions, or do you want to be heard?
No, thank you. I'm happy to hear the board's views.
You may state your own too, even though your vote is not, you won't be voting on this question, Jerry.
Thanks. I understand that, but I'd like to hear other people's views first.
Very well.
So the question.
Yes.
So did the vote and the proceedings of our prior meeting bind us to delaying the deliberation and finalization of findings of fact in the decision to next meeting? Can that not be done at this meeting tonight?
Given the draft, and they're only draft, Sandy's reminded me of that, minutes that I have reviewed, and Sandy has indicated that she watched the proceedings before she took down this motion that was made, I would say that you can't properly bring the findings of fact before the board tonight.
Cannot.
Cannot.
Okay, so we're bound to filing that no sooner than the 7th with the clerk.
That's correct. Now, I'm not sure that it's frankly material
Just a
at this
question.
point.
Understood.
But the sooner you get it done, obviously the better. But folks are on notice, including the petitioner, that that's when it was going to happen.
Yep.
And I think that and frankly, the agenda for tonight is a discussion of what you're going to do about the claim for constructive grant. The agenda isn't to adopt findings of fact. I would caution you to stay with January 6th.
Okay.
In fact, there were findings of fact made at the December 5th meeting? No?
No, there weren't any.
There were none.
No.
But the vote was,
The vote was up or down on the variance.
The
Then it
draft
was-
minutes say it was a motion to deny the variance, and 3 voted to deny, and 2 voted not to deny. And there is a reference that those voting, in reaching its decision, the board reviewed the following, and it mentions the application, the plans, the flood zones, those kinds of things, but there's no real findings of fact here.
normally they precede the motion to actual take a vote.
Ordinarily, they do. In this case, my memory was that when we started with a motion to adopt findings of fact, Mr. Taub interrupted and suggested that it may be more prudent to spend some time, whoever was moving the findings of fact would spend some time to prepare a decision and then present it to the board. I had began the motion for adoption of findings of fact. I withdrew the motion and and seconded Mr. Taub's motion. This is my memory.
Yeah.
And then all members agreed that we would, the next regular meeting, which would be January 6, 2016, the decision would be announced, but there would be no further discussion by any of the voting members one way or another as to the content. In other words, it was to provide time to prepare a comprehensive decision.
In that sense, I'm asking since I wasn't present, in that subsequent motion on the request for the variances was taken and...
That was the first motion. The way it was framed is whether the variances ought to be, the request for the applications should be denied or approved. And that's when the 3-2 vote defeated the application. Then the question was, well, how about the findings of fact in a decision? And that decision was deferred. I mean, that action was deferred until January 6th. But at that point, my memory was that the preparation of the decision and the adoption and announcement of it in January was completely ministerial. Does that make sense to you?
It does. I mean, it's just atypical of the sequence.
Yes, usually the findings of fact are adopted with appropriate amendments and voted on at the hearing. This, Mr. Taub felt was less appropriate to take that procedure was less appropriate because of the complexity of the questions and the fact that you needed, we were dealing with a variance and findings of fact had to be tailored in a much more sophisticated manner in view of the fact that there was a division of opinion amongst the members.
And maybe a question to town council is there any necessity or prerequisite to have findings of fact before a vote to approve or deny?
Well, generally, findings of fact precede an ultimate vote up or down on an application. Usually there's findings, and then based on the findings, there's a motion to approve or disapprove,
Right.
as the case may be. Can a motion be made to deny and then the findings afterwards? I don't think it's precluded. What the statute says that you're supposed to make a detailed record of your findings and vote, and in making that detailed record, then you file that with the town clerk. So I think the fact that you tabled as a board until January 6th the approval of the findings of fact, they're still in play and could be amended or whatever in support of the vote, which was to deny the variance. But you're correct. You normally see findings of fact precede a vote up or down.
And
that's good practice.
And I asked with the hopeful answer that you gave, that in fact it's not it doesn't create a defect, if you will, procedurally in that could...
Well, I think as long as you make some findings, that you're all right.
So then the question, as you went through your options, was with respect to the 100 days, which were, I think, presumed, let's say, to be extended by the request for extensions or continuations made by the applicant at various points, so that in either event those became cumulative, with the question of tolling being separate and not not a precedent for. So it is beyond the 100 days at what point then?
The 100 days was October 18th, unless there was an extension.
Okay, and for purposes, arguendo that the extensions as requested, as a request by the applicant to the board, that there was arguably consideration on both parts to form that quote agreement that settled. So
let's assume that those requests and the subsequent votes granting the request were extensions, that the minutes show those, that the minutes are filed with the town clerk, so we have an agreement. All right? That's one way to view the facts. If a court finds that those specific formalities of Section 15, that there has to be a writing, a written agreement that specifically mentions the word extension, and you're extending it to a particular time, and that gets filed with the town clerk, well then, if that's the only way to perfect it, then those aren't extensions. But let's assume that a court says, yeah, you can, those count, all right? That gets you to December 2nd. And the request for a constructive grant has to be filed with the town clerk in writing within 14 days from the expiration of the 100 days. So if the 100 days didn't expire on October 18th, but it expired on December 2nd, 14 days is December 16th. Now, if I'm representing the applicant, I'm going to say, well, my extension was to December 3rd because I knew it was to the night of the 2nd, and you could never file your decision until the 3rd. So really, I had 14 days from the 3rd, so when I filed on the 17th, I'm okay. I mean, I can hear what, there's going to be a lot of different theories here.
So if we, my belief is that implicit in the agreement to continue the hearing, we were all agreeing to toll that time limit. So, so I believe that the 100-day meter was stopped from September 2nd through December 2nd, which means 53 days had expired, 47 days remained, which gives us until January 17th.
Okay.
Before the
so you as a
100
board
days
member
expires.
thought it was a tolling. That was your understanding.
Absolutely.
All right. Even though there was no discussion, that's how you kind of considered it.
Absolutely. I
Okay.
mean, I don't think either party focused on the 100-day deadline or focused in on that point, but I think implicit with agreeing to continue is that deadlines are then and therefore extended. And hey, I vote. I was one of the two in opposition, but I think that that it's important that the board's vote holds, and that again we have until the 17th.
Thank you, Mr. Cole. Any other commentary before I weigh in, Mr. McCartney?
The fact that we don't meet for the month of August.
I will say that my view is exactly as Matthew expressed it.
Thank you, Mr. Mulligan.
The
Mr.
fact
McCartney?
that we don't meet the month of August, does that 30 days still count?
Yes.
Okay.
Yes.
Just wanna-
Yeah.
We're jockeying for the date. I just
Right.
want to be sure we had the.
No.
Okay.
Applicant's entitled to it. It runs.
That's a good
Can I
point.
ask a procedural?
Yes.
I think that you said that if we chose to do nothing, it would fall on the town clerk, and that your recommendation to her would be that she
If
do
asked.
nothing.
Mm-hmm.
So if she does nothing and we file our decision, doesn't this put the whole thing back on the applicant again to appeal our decision?
But the danger in that is that you, if it turns out to have been a proper constructive grant request, and you never appealed it,
Didn't appeal it. Okay.
your
Okay.
sole issue was whether the clerk should issue something to them. That's all a court will then deal with.
These are my comments, and I certainly, as chair, wasn't paying attention to any particular timetable. I now am more sensitive to the fact that the meter was beginning to run, even though culturally this board doesn't meet in August. But the fact of the matter is, I'm practical enough to look at what was in front of the board at any particular point in time. And we know that in September, the board needed more information the applicant agreed to provide it, and it wasn't until and there was a plan which was filed immediately before the hearing on December 2nd, on which the applicant depended to support his claim for relief. I say that that was truly when the application was filed. Now, I recognize that the statute says filing with the town clerk, that the 100 days begins to run. But as a matter of fact, given the realities of the situation and the way that the board and the applicant were dealing with each other, then we don't even deal with that 14-day period as long as the 100 days hasn't elapsed. So for all practical purposes, I'm thinking that the meter really started to run on December 2nd. And that is writing or no writing, because there's a scarcity of writings about that question, because nobody was raising it. And you mentioned one particular theory where regarding the timeliness of the demand for constructive approval, which stood for which basically the underlying purpose of that is to give the zoning board a warning as to what timetable the applicant is relying upon. And that never really happened. There was nothing in the chronology of the way the board and the applicant were dealing with each other that there was any timetable being run. There was never any objection, even in view of a disappointed applicant on December 2nd having received the vote, that there was no objection as to the continuance finally to a point of time that hasn't even arrived yet, next week, when no one is to complain that the applicant, having been aggrieved, could proceed to the Superior Court. So I believe that the board should, and recommend to the board, that the board should appeal the grant of constructive approval. It surprises me and heartens me that if the board so chose to do that, would be a plaintiff in the land court action, and also have the extra string to its bow to protect the integrity of its decision. And I appreciate those members who voted to approve the application are in basic support of this procedure now, all of which is meant to validate the zoning board in its efforts to enforce the zoning bylaw the way it conceives it to be. The planning board considered this at a meeting this afternoon and has declined to make any statement to the board tonight. But the sense was that the planning board is trusting in the discretion of the zoning board. Are there any further comments?
Isn't in the fact that we are the special permit granting authority for the case, so how is it that it might otherwise be the purview of the planning board?
It may not. Oh, because the planning board is a municipal authority or agency which would have the right to, in its own name, file an appeal from.
Of any decision of yours.
So
Interesting.
there was no expressed disagreement with the action or decision of the zoning board.
Go ahead, Mike.
if our position is that the 100 days hasn't expired until some date after January 7th, at which time we expect to file our decision, is the appeal a necessary step in tandem with filing our decision, or is there any other path to refute that?
Well, as I indicated, if you did nothing and the town clerk chose not to issue the required or the requested certificate, and litigation ensued, and that litigation would be in the nature of some sort of mandamus to require the clerk to issue the certificate.
So it puts the onus on them to take that action.
It does,
Applicant.
but the Board of Appeals is now out of, you're not a party to that.
Okay.
And if it turns out that they prevail and the clerk is forced to issue the certificate, then what you do on the 6th or anything else is simply moot.
So we would have lost the chance to appeal at that point?
Yes.
Okay.
So that's why the statute was amended a number of years ago, 87, I think, requiring an applicant who was going to raise the issue of a constructive grant to give notice of it to the town clerk, to the board, all parties in interest, to give them an opportunity to take an appeal within the 20-day window.
Okay.
And that was within the 20 days of the 5th?
17th in this case. They filed this request with the clerk on the 17th.
Okay.
And so the statute says you have 20 days to appeal that under Section 17, just like, this is considered just like a decision of the board, and you'd have to take an appeal, just like any other decision.
Would our, if the vote were to take the appeal, would that include a count, if you will, that in fact
Yeah.
the
On the merits?
appeal was moot or late, if you will, in a sense of, on the 17th
Yeah,
being?
well, I think that if you decide to appeal, and that's your decision, and I don't, you need to come to that. I think you're deliberating now. That my recommendation is that you would instruct me to, in the appeal, to object to the issuance of the constructive grant, and in the event that the court found that there was a constructive grant, to challenge it on the merits. I would think you'd want both, but that's...
So that it was not timely and that appealing on the merits.
Right.
So we could capture both.
We'd capture both. You'd have two counts.
Good.
Because it's a couple.
It strikes me that if indeed the 100-day run, if you will, somehow were not affected by extensions or continuations made at the request of the applicant, that would in fact be a strategy that everyone should follow in order to end up with a constructive grant on a...
Well, let this be a lesson, because there is a form, and anytime you ever get a request for a continuance, the form should be read on the table, should be signed by the applicant, the chairman of the board, if the continuance is granted, and filed with the town clerk. It's a very simple thing. It's a form but you need to have that and be aware of it at all times.
So you suggesting that form speak to the tolling?
That form speaks to whatever the two parties agree will be the extension.
Okay.
Because the statute doesn't use the word tolling.
Okay.
It uses the word extension. But if you're on the board and on September 2nd, you know the 100 days, because somebody is keeping track and telling you, expires on the 18th, and they request a continuance to November 2nd, you say, hey, look, we want an extension to at least 30 days after November 2nd. Give us time to deliberate, get our decision together, get it filed. As a board member, you should always look to give yourself the addition so you're not caught in these situations.
Hence the significance of the minutes having been filed with the clerk to
Perhaps.
at least
I didn't find a case on it, but perhaps that will.
at least evidence of a. And did the minutes indicate that the applicant requested?
Yes, they do, the ones that I've seen.
So there's a consideration again
And I
that
thought that covered us, but it doesn't cover us quite quite all the way.
Um,
So when we get extension requests in the future, they're gonna have to come in person and request them. We can't be nice and say, oh yeah, we'll consider it.
I also think that on September 2nd, the application was incomplete because their materials weren't up to our filing requirements, and I think we were polite in the way that we asked them to revise them, when in fact the application could have and should have been rejected.
Well, the time to do that is before it's published. Before the, you simply don't take it in. You have a checklist.
Yep.
Doesn't have the plan stamped by a professional. It's not taken in. And an application that is never complete, the time period never starts running.
Right.
Who's
Who's that gatekeeper? Is that you or is that Tom?
There isn't, we don't have one. We don't have one.
Who stamps it?
Town clerk.
So she's essentially at this point judge and jury as to whether it's complete?
Well, great question, Matt. And so my experience in most towns is that the building inspector or some professional signs off on a complete application. And until that happens, the town clerk doesn't take it in.
Yeah, okay.
Town clerk says, where's the stamp from the building commissioner or from the zoning department or the planning department that you have a complete application?
Mm-hmm.
Otherwise, they don't take it. So there's a gatekeeper role.
Okay.
And your regulations, rules and regs of the ZBA, could lay all that out.
Sure.
Is there any further discussion, members of the board? Since there is no further discussion, I propose the following motion to authorize the filing of a written appeal from the petitioner's notice of constructive grant of variance and objection deadline, an appeal pursuant to General Laws, Chapter 48, Section 17. Is there a second?
Second.
Any discussion on the motion?
Just, Mr. Chairman, I question the town council whether the reference to statutory appeal is a
4817 is proper, it's referenced right in the statute.
just in terms of our wording, should the word statutory appeal as a,
I think,
if it's
you did cite 4817?
if it's implicit, then I'm
Yeah, I'm
okay.
comfortable that it is.
Okay,
Yes.
great.
Any further discussion on the motion? All those in favor?
Aye.
And opposed? Motion carries unanimously. Thank you, Mr. Jablin and Mr. Mulligan, for your participation.
Thank you for the opportunity.
If there's no further business to come before the board, will entertain it. Second?
Second.
Mr. McCarthy. All those in favor?
Aye.
And opposed? Motion carries unanimously. Thank you, Mr. Fuller,
You're welcome.
for your time.
Yes, thank you very much.